We have massive breaking news right now because literally minutes ago, a federal judge in Rhode Island ruled that the Trump administration must pay out SNAP benefits for 42 million Americans, at least partially, heading into November. A stunning ruling by Judge John McConnell from the bench in Rhode Island. But that's not the only case. Another judge in Massachusetts minutes ago also determined that the Trump administration's plan to block SNAP benefits for 42 million Americans was likely unlawful. Two separate judges in two separate states in the same, literally same 10-minute period in the past 5 minutes issued separate orders. And I want to break both of them down for you and what this means for SNAP heading into November. Please consider liking, sharing, and subscribing to spread the word. I'm getting you this news first as it breaks. The first is Judge John McConnell in Rhode Island. Judge McConnell ruled that the Trump administration is unlawfully withholding contingency funds that were appropriated by Congress to SNAP programs. It's about $5.5 billion worth of contingency funding. This funding must be used to pay SNAP benefits. Now, let's talk about what that means. To pay SNAP for about a month, you need about $9 billion. $5.5 billion is not the full nine, but it'll get you close. It'll be enough to pay out 3 weeks worth of SNAP benefits for 42 million Americans who will lose the right to get SNAP and food assistance tomorrow because of the ongoing government shutdown. And so this is a temporary fix, but it's a significant one nonetheless. It is a significant one nonetheless. Now, the second judge essentially ruled that we're not going to issue a temporary restraining order just yet. I'm going to give you until Monday. But essentially, Donald Trump, your interpretation of the law is incorrect. So that's the second judge's ruling. But Judge McConnell says, Trump, you have to pay out SNAP benefits. You have to do it. So at least partially. So 42 million Americans, as long as this ruling holds, you're going to get some type of SNAP benefits. That is significant. And that is the top line ruling here. Now, the second judge, her name is Judge Talwani. She ruled also just minutes ago that the Trump administration plan to shut down SNAP is likely unlawful. So let's look at this ruling together because I think it's important that you guys know it fully. So she is her name is Judge Talwani. She's an Obama appointee. She writes, pending before the court is plaintiff's motion for a temporary restraining order seeking to enjoin on an emergency basis defendant's November 1, 2025 suspension of benefits under the Supplemental Nutrition Assistance Program. For the reasons stated below, plaintiffs have standing to bring this action and are likely to succeed on their claim that defendant's suspension of SNAP benefits is unlawful, where the suspension of benefits rested on an erroneous construction of the relevant statutory provisions. The court will allow defendants to consider whether they will authorize at least reduced SNAP benefits for November and report back to the court no later than Monday, November 3rd, 2025. Now, she goes through how since 1964, when SNAP was first established, it was known to serve as a, quote, supplemental nutrition program to permit low-income households to obtain a more nutritious diet through normal channels of trade by increasing food purchasing power for all eligible households who apply for participation. Congress appropriates funds for SNAP benefits each year. The annual appropriation consists mostly of one-year base funds and sets aside a portion of the appropriation as 3-year money for contingency funds. The United States Department of Agriculture administers SNAP at the federal level, but relies on state agencies to implement SNAP locally by processing applications, certifying eligible households, and calculating the amount of benefits for each household in accordance with applicable laws and guidance. SNAP requires, as she notes, approximately $8.6 billion of funding per month, of which $8.2 billion SNAP benefits directly and about $450 million covers administrative fees. Now, the present dispute was whether or not those contingency funds could be used to cover at least part of that $8.6 billion bill that SNAP has to be covered every single month. And well, here, the judge says yes. Both judges said yes. And I'm reading Judge Talwani's decision today, even though she did not go as far as Judge McConnell, but ultimately the ruling is what it is. And the reason why I'm reading Judge Talwani's decision is because she actually issued it. This went to my inbox, whereas Judge McConnell read his decision from the bench. So you don't have his decision in print. Judge Talwani writes that the plaintiffs have a likelihood success on the merits of their claim under the Administrative Procedures Act because defendants' suspension of SNAP benefits is contrary to law. At core, defendants' conclusion that USDA is statutorily prohibited from funding SNAP because Congress has not enacted new appropriations for the current fiscal year is erroneous. To the contrary, defendants are statutorily mandated to use the previously appropriated SNAP contingency reserve when necessary and also have discretion to use other previously appropriated funds as detailed below. When Congress established the program in 1964, it did so in part to utilize the nation's food supply to the maximum extent practicable to safeguard the health and well being of the nation's population and raise levels of nutrition among low income households. Pursuant to the Food and Nutrition Act of 2008, assistance under SNAP shall be furnished to all eligible households, subject to the availability of appropriated funds. As both parties acknowledge, Congress has not yet appropriated new funds for SNAP for the fiscal year 2026. But Congress took steps to protect against deprivation of SNAP assistance in prior years. And right now, while defendants argue that there is no available money in the annual account, under defendant statutory construction, the use of separately appropriated contingent reserve to fund SNAP benefits is somehow predicated on Congress's annual appropriation of funds to the SNAP program, but Congress placed no such restriction in the 2024 Consolidated Appropriations Act. And so she concludes by saying, quote, the motion for temporary restraining order remains under advisement. No later by Monday, November 3rd, defendants shall advise the court whether they will authorize at least reduced SNAP benefits for November, and if so, their timeline for determining whether to authorize only reduced SNAP benefits using the contingency funds or to authorize full SNAP benefits using both the contingency funds and additional funds. So that's her ruling, which essentially says, we're not going to order you to do it just yet, but what you're doing is unlawful, Trump. And if you don't let us know by Monday, then we're going to make sure then we're going to follow up. But another judge, essentially Judge McConnell, said, we're going to go one step further. You must go forward. You must use emergency funds. Judge McConnell did that in Rhode Island. So he issued a temporary restraining order from the bench. He says that the program must be funded using the contingency funds and asked for an update on progress by Monday. So multiple judges coming to the same conclusion, but ultimately Trump has to pay out these funds, and they want an update by Monday. We'll see what happens next. We'll see whether they appeal. As always, you're getting the news first from me, so like, comment, share, and subscribe to support my work. I will not stop, not today, not ever, and I'll see you soon for another update, so stay tuned.